All right, be seated, everyone. We are on the record. The jury is now present and we are ready to resume.
Thank you. All right, we were talking about projection charts when we left for lunch. Hopefully the food in our bellies doesn't put us to sleep thinking about projection charts. But the charts that you included in the projections, what served as the foundation or the investment capital? Was it just the 175,000?
No, it was both our money. So it was the 94,000 that I put in that had grown, and then it was the 175 that came from the home sale.
Okay, had you guys talked about doing that, contributing your own separate money to the account?
Yeah, we talked it over, and it made sense to have all the money in the same trading account rather than having it be in separate places.
And did that ever actually happen?
Yeah, it was I think the house sale was in July, and then by, I don't know the exact month, but maybe September or October, all the money was in the same account.
When did the tiny houses get built?
Years before that, the tiny houses got built in 2018.
Now,
I'm sorry, I didn't hear if you said 19 or 18.
18.
Thank you.
2018.
now, wasn't it your testimony that the tiny houses were built with the 94,000, or some of it?
Yeah, they were. They were built with the 94,000 that had grown to 205,000.
So was there still 94,000 in that account?
I mean, the amount was different because, right, it had grown, and then we took money out for the tiny houses. So is your question asking about the value of the account or the principal?
Yeah, I'm trying to keep track of the accounting because it seems like, well, we'll get there. We'll get there. All right. Let's look at. I want to make sure this is not being projected. All right. Do you see that, Mr. Hussaini?
Yeah, I see the Bosslandia lease agreement.
Mothership Residential, aka Bosslandia lease agreement. What's the date of this agreement?
This was 2021.
Okay, 2021. And again, I'm going to scroll through. It's kind of a long document, but I'm going to scroll through. Oh, whoops. Scroll through and try and get to that signature page without losing the text. Okay. Is that your signature? Electronic signature?
Yeah, that's my electronic signature along with Iwana's and her niece and her niece's partner.
What's the date of your signature?
Looks like I signed after everyone else on the 14th of August,
August 14th. What year?
2021.
Okay. We'd move to Defendant's Exhibit 12, Your Honor.
Objection.
Thank you. Defense 12 is admitted.
And asked to be published to the jury. So once again, onto the top here. So once again, we have Ioana Sammartinian, hereinafter referred to as landlady. What was your understanding of that term, landlady?
It was a term that carried over from year to year. Like I said, we copied the last year's lease and then sent it on DocuSign to her niece, Elise. I don't know that I read any meaning into it.
You didn't read any meaning into it?
No, I didn't scrutinize the documents. We just wanted to make sure that every August, we sent it to Elise and make sure that she signed it.
Okay. There's a highlighted portion down here.
About dog poop.
Yes. Did you see that part?
Yeah, so every year we'd go through and we'd highlight the things that we thought were important, that we like added or wanted to emphasize to a lease.
Okay.
And like their two dogs, they weren't good at picking up after them, and so the front yard had kind of gotten like away from them. So we wanted to make sure that they picked up after their dogs.
Did you have any input as to this addition regarding dog poop?
I don't think so. I think this was something that Iwana added. So she was like bothered by how the house looked with the dog poop in the front yard.
Okay. But you did sign it.
Yeah, I signed it.
And regarding binding effect, we looked at this with respect to the 2022 version, and don't die was highlighted.
I don't remember why we decided to highlight it that year. But
Okay.
I'm pretty sure that's something we added into the form.
Okay. Did you have any input as to adding that particular provision?
I don't remember. I mean, it seems like tongue in cheek, so it was probably me.
Tongue in cheek? Is that, I'm sorry, I just want to make sure I heard you right. You said tongue in cheek?
Yeah, that's what I said. So like
Okay.
the tongue in cheek sarcastic comments were probably me, and like the more serious stuff that actually had to do with dealing with the tenant or like the more contract type stuff, that was probably Iwana.
Okay. But you signed here as agent. In your estimation, is that a proper title for you?
Again, I don't know what an agent usually does in a real estate relationship. What was happening in reality at the time is that Elise was paying me. She was sending the Venmo to me. Like that was a conscious decision between me and Iwana. We talked about it. We communicated it together to her niece, that the Venmo would switch from Iwana to me. And then when we filed taxes, because every year, because we had that shared account, like I'd help Iwana with her taxes. At least for the investment part, her mom would help with the rest.
Okay.
We made the joint decision, like me and Iwana was like, oh, okay, the rental income, Zubair, you file that on your taxes. So that's what was happening in reality. I don't know if that lines up with what an agent normally does or doesn't do. That's what was happening.
Okay. And let's talk about access by landlady. Is this referring to Ioana?
Yeah, so me and Iwana both together did stuff like changing the air filter every month for them, making sure that the smoke detectors were working, checking under the sink for leaks and stuff like that. So yeah, landlady referred to her, and
Okay.
landlady's agent referred to me.
Okay. And again, we have landlady, tenant in paragraph 5, tenant shall not allow any other person other than tenant's immediate family or transient relatives and friends who are guests of tenant to use or occupy the premises without first obtaining landlady's written consent to such use. How come it didn't, it did not require your consent?
No, I think this is one of the things that we just copied and pasted. I don't think we ever changed this at any point.
Okay. All right. Tenant shall pay to the landlady the sum of $500 plus $250 per roommate per month as rent for the term of the agreement. How did you guys come up with this amount for rent?
So this happened like back when we were planning out the tiny houses, and you know, Iwana was saying, well, I think it's going to cost $50,000 for the two of us to do it. So we should probably charge them $1,000 a month for rent. But when she had first pitched the idea to Elise, I think she told Elise $500 for rent instead of $1,000. And so when like everything came due, and we thought the tiny houses were going to be cheaper at first. Like we thought they were going to be like 25,000 total. And you know, after they were built, and we're like, oh wow, it cost 50,000 to build these things. Me and Iwana were like, okay, maybe 500 a month, which is what she wanted to charge Elise originally, isn't going to be enough. And so, you know, we're like, you know, $1,000 is probably still fair. Like that's still below what you can rent a house for. And that's how we came up with the 500 plus 250 a roommate. Originally, Elise moved in with her partner and like a close friend of hers. So there were two roommates, and the 500 plus 250 a roommate got to like the $1,000 that tied into what we thought was like what would make it make sense for how much the tiny houses cost.
Now, I'll remind the jury that this is following this the sale, right? The purchase of the property. How much was the mortgage on the mothership at that time?
So the mortgage was like it was like $1,150. I remember 11 or 1,200, and then with utilities, electricity and internet, like the bills for the house came to $1,400 a month.
So 750 was roughly half.
Roughly half, yeah.
Okay. And that basically covered Ioana's share of the mortgage, didn't it?
If you count it as her contribution, that's the amount that she was supposed to pay, but it came from Elise. It didn't come from Iwana.
Okay. We talked about earlier, you're of the impression that even if Ioana hadn't been the quote unquote landlady of this property, Elise would still have rented from you?
For that price, yeah, I think she would have loved to be like near family, near her aunt, and away from her parents, and like in a place that's her own.
And if Ioana hadn't been involved, let's say would you have made such an offer to Elise?
So that was the question. I apologize, I didn't answer it. So even if Iwana wasn't there, like Elise knew me, I watched her grow up. And if I said, you can rent this place out for less than you can get anywhere else, and you'll have a house to yourself as you go through college, I do think she would have taken me up on that offer.
Okay. All right. And so roughly half the mortgage, and then whatever was left over that went to utilities?
Yeah. So utilities and mortgage together was like $1,400 a month, and I was paying that. This covered about half of it.
And what'd you do with the money once you got it?
We had this set of shared accounts at like Ally Bank. So Zubair, Iwana, we had this portmanteau of our names, Zubiwana. So we had like I said, like a dozen bank accounts at Ally Bank. They don't charge you for an extra account. And we called them things like Zubiwana utilities, Zubiwana mortgage, Zubiwana groceries. And so like we'd put it in like the shared, like I would get the money on my Venmo, then I'd move it into our shared account.
Okay. So as late as 2022, you're signing a lease agreement that says that Ioana is a landlady. And then you testified that things kind of went sideways in 2022. Is that correct?
Yeah, it was the end of September, beginning of October that our argument started, that we started talking about how to unwind things.
And did you say something to Ioana that set things off?
We talked at first, like for a month or two. Like I said, I think I'm a really easy person to argue with. I don't yell, I don't scream. But things still got tense. And then there was, yeah, the graph paper document. That's how I think of it in my head, that she asked me to sign. And then after that, we were only emailing back and forth because like every time we like were in front of each other, like she would yell. So we tried doing things just through writing.
Okay, so you mentioned the graph paper document. I'm going to bring up plaintiff's admitted exhibit. What's the 2022?
Ownership?
Oh, it is, what are you
Like
looking for?
5 or 6.
2022 affirmation.
You're talking about, I'm sorry,
The graph paper document.
3?
3. It's 3.
There we go. Okay. So agreement regarding 15824 North 22nd Way, Phoenix, Arizona 850. Is that a 022?
15824 North 22nd Way. Yeah, 85022.
Okay. So this agreement affirms and ratifies the relationship we have concerning the property at the address. Both parties agree that the name on the title/deed does not reflect the ownership interest in the property. No ownership interest changed as a result of the July 2020 transaction between us. Joanna's signatures there, and then you're debuting a new signature, correct?
Yeah, I changed my name that year. Like I added the Mahtab Shah to the beginning.
Okay, but you do agree that that's your signature.
Yeah, that's me.
What did you intend by this agreement?
So with this agreement, I was trying to reassure Iwana. Like I said, we weren't talking like at this point. Like she was crying, she was screaming, like she didn't want to discuss how to unwind like our financial stuff. And she said she would only keep talking if I signed this. And so my primary goal was to reassure her. And what I was trying to say with this was, look, I know the house has gone up 100,000 in value since I bought it from you. If that's, what you want, I'm still willing to sell you the house at my cost.
Okay. Did you intend something other than both parties agree that the name on the title/deed does not reflect reflect true ownership interest in the property? Did you intend something other than that statement?
So this is Iwana's handwriting. She wrote this. And the way I understood it was, at the time and still today, it's just my name on the title. Like the house, if you look it up on the Maricopa County Recorder's Office, just has my name as an owner. And I was trying to tell her that I'm not trying to screw you over. Like it's just me here, and the house is worth like 120,000 more. I get that there's this complicated situation where you have my money in the investment account, and I have this house that has a lot of value that you're saying should be yours. I'm not going to try to screw you over just from what's on the paper.
So did you intend something other than both parties agree that the name on the title/deed does not reflect the true ownership interest in the property?
Yeah, I mean, the way I meant it was, what I meant and what I thought I was trying to say was, if you want to buy the house back from me at cost, you can do that. Otherwise, this doesn't make sense, because it's saying yeah, I took on a mortgage on your house. I paid off your first mortgage, but the house is still yours. Like that doesn't make sense.
Well, we'll talk about whether it makes sense, but what I want to know is, did you intend what you signed?
What I intended was to spell out my portion of the deal. So like this doesn't say anything about her part of the deal. I was trying to just describe what it was that I owed her without describing the whole thing.
Okay. Let's go to the next line, the last line. No ownership interest changed as a result of the July 2020 transaction between us. Did you intend that statement when you signed it?
So again, this is something that Ioana wrote. That's just her handwriting. And at the time, like what she was saying and what I thought she wanted was she wanted to, at the end of this, after, I got my money back from the investments and we untangled everything, I thought she was saying, I want to be the one that lives in the house. And I was fine with that. Like I was willing to go out on my own and, find a place to rent. I thought I was just agreeing to that. Like however this ends up, one of the things you get is the house. Like I didn't think, still don't think, like what I meant by this was that I'd keep a mortgage in my name that I have to pay. Ioana keeps all the money and she gets the house.
Well, what do you understand by ownership interest?
So I thought this was talking about like the value of the house that had gone up, like the increase in value, like from the point that I bought it in 2020 to when we signed this in 2022.
Okay, so you're saying ownership interest equals equity?
Yeah, I thought that's what this was about. I thought she was trying to say the house has gone up in value and I should earn that. And that's what I thought I was signing. But again, like that's not the whole deal.
Was there a discussion about equity at that time?
Yeah, we were talking about equity. I was trying to get her to explain, where do you think your equity is? Like, do you still think it's in the house, or do you think you sold the house and now you have 175,000 of equity? So we were talking about this, and I was trying to explain that it can't be in both places. Like, you can't have the equity in your house and then also like just equity in an account in cash somewhere else.
Are you familiar with the concept of a trust?
No, not really. That's not something I've ever worked with, or I've never set up a trust for myself.
Okay. Have you ever heard that phrase used, a trust?
Yeah, some of the people at work, when they do their estate planning, I've heard them, talk about lawyers or accountants setting up trusts for them to, make sure their affairs are in order.
With respect to the purchase of the house, you signed a deed of trust, isn't that correct?
Yeah, the stack of papers is like this high when you
Sure.
sign a house, and I think that was one of them.
And are you familiar with what your role was under that deed of trust?
No. Can you show me the document?
Sure. Let's see. Oh, this one hasn't been published yet. So a recorded document, Your Honor, I'd ask the court to take judicial notice of it.
Well, I'm not sure what you're asking me to do.
So,
Are you asking me to admit it?
yes, Your Honor.
Is there an objection?
Well, maybe you should lay some foundation first on what it is with the witness.
You're asking me to admit it because it's a recorded document.
Yes, Your Honor.
I don't know what the relevance is yet, so I'm going to sustain the objection.
Very good. All right. But you can see the document, Mr. Hussaini, correct?
I can see the document.
And are you familiar with this document? Have you ever seen it before?
Yeah, this is one of the things in the stack of papers when I bought the house.
Okay. Do you see the stamp in the top right corner?
I do.
Does it say official records of Maricopa County Recorder?
Yeah, and then it has like I think a name of the secretary or something, and then
Adrian Fontes.
Yeah, I think I've seen his name on a sign.
And then you have a number 2020-065-7875. The date is 07/22/2020. Is that correct?
Yep, that's what I see.
Okay. And I'm going to scroll through it so you can see everything here. So your name there as borrower, you see that?
Yeah, I do.
And you see lender, you see trustee, and then we have a bunch of terms, right? You mentioned a big stack of documents, right? Here we have the property description. I'm going to zoom down to your signature. Okay. Is that your signature?
It is.
It's the old one.
It's the old one.
Okay. Move to admit. Well, I guess this is yours. I don't want to admit your version. All right. Sorry about that. Deed. There it is. Our version, defendants 5. Move to exhibit or enter defendants 5, Your Honor.
No objection, Your Honor.
Sorry.
No objection, Your Honor.
Thank you. Defendants 5 is admitted.
Okay. So, actually, this is
Looks different.
a different one. This is the second one.
Okay.
Second. Do you have any objection to this one?
I don't know what it is.
It's the second deed of trust, the 2023 deed of trust.
For the second mortgage.
Oh, okay, just, can you ask him just a few questions, lay foundation so that he knows what it is?
Yeah, can we take it down?
The normal way.
Sorry.
Admitted.
Oh, it is admitted?
Yeah, you offered it. He didn't object. I admitted the document. So if y'all want to unwrap that, please tell me now.
No,
that's
we don't. I don't want to. It gets the stamp. Oh. Okay. So what I'm looking at here is you are listed here as the trustor. Credit Union West, the lender, is listed as the beneficiary. Is that correct?
Yeah, that's what the words say.
I'm sorry, you're listed as a borrower, the trustor and borrower. Credit Union West is listed as the trustee and the beneficiary. And then they're also called the lender. So they have lots of roles under this deed of trust. So your role as trustor for the house with respect to the lender, what's your understanding of that?
That word I don't know. I understand borrower. Like I borrowed money.
Okay. Does the lender have any interest in the house?
If I don't make payments, they take the house.
Okay, fair enough. And what happens if you were to set fire to the house? Would they have any interest there?
I think I still have to make my payments.
Still have to make your payments, okay. And what if you were to transfer title to someone else?
I don't know. I assume they'd want all their money back.
Okay. So to some degree, they're asking you to take care of the property. Isn't that correct?
Yeah, I think that makes sense because, you know, if I stop paying them, their collateral is something that they have an interest in.
Okay. Now let's go back to Exhibit 3. Isn't it possible? In fact, isn't that the intention here is that you and Joanna were trying to set up a trust arrangement?
We never talked about a trust arrangement, not in any one of the emails or talks that we had like in the 4 months when we were trying to figure things out.
Well, you like you said, you're not a lawyer, right? So maybe you didn't know that term. But isn't it Isn't it the case that she meant for you to take care of the property?
I lived there, like, I was expected to pick up after my dogs. Um, the other thing that you're kind of implying is that, I'm some sort of yard keeper or,
Well, I'm not using the term yard keeper. I'm using the term trustee.
so we never talked about trustee. I think you used the word take care of the house. Never used the word caretaker. So that wasn't a part of our conversations.
Okay. And did you intend something other than what is written on this 2022 agreement?
What I intended was to tell her that she could buy the house back from me at cost and we could undo what we had done. That was my intent with this document. There was a lot of other stuff. Like when I signed it, I thought she was going to give me my money back from the investments for signing this. So like it's not complete. Like it doesn't talk about everything in the deal. But the part that I was trying to describe was my responsibility, which at the time I felt to be that I would sell her the house back at cost.
At what cost?
At my cost, the 231.
She testified earlier that that wasn't your out-of-pocket cost. That was your out-of-pocket cost was something like 45.
So at this point, yeah, I've been paying the mortgage for 2 years, and I put the 25,000 down. But I had this mortgage in my name, like I was using credit, and I didn't want to be tied up with a mortgage in my name for 30 years. What if I wanted to go buy a house like on my own? I'd just have her using my credit to like have this mortgage that's at 2.75%.
Well, so then why sign this document?
I signed it to reassure her because I wanted to keep talking because like there were lots of things to figure out still. And I was hoping that we could figure them out instead of having, everyone else figure it out for us.
Have you ever bought a car?
Yeah, I've bought a car.
And was that a high pressure purchase scenario?
So not for me, but I helped my brother-in-law buy a car, and yeah, those salesmen, that they know how to like lay on the pressure.
Do you take the first offer they make to you?
I think the general advice I've read everywhere is shop around and don't agree to the first number.
Okay. So did you vocalize any sort of objection to this statement?
Yeah, I did. I mean, like she was screaming, crying for 2 weeks, and she wanted me at first to do a quick claim on the house. And my understanding of that is that essentially I would just be signing over to have her name on the property as well. And that way there would be no way for me to guarantee that she'd ever give me the money back from the investment account. So I said no to the quick claim.
Okay. Was that the only reason?
The fact that I wouldn't be able to have any way to get my money back.
Sure. Was that the only reason that you said no to the quitclaim deed?
That was the main reason. I don't remember all the reasons going through my head, but yeah, that was probably like the 90% of the reason why I said no to that. And then there was another version of this also that I said no to.
Did a quitclaim deed get signed?
No.
There wasn't a quitclaim deed signed and then just not recorded?
No, that never happened.
Okay. All right. I want to go back to the deposition. All right. You recall that you took a deposition in 2024 in this matter?
Yeah, around October, I think.
And one of the questions is very similar to the one I'm asking you right now about this graph, what did you call it? Graph paper agreement?
I called it the graph paper agreement, yeah.
The attorney then asked, no ownership interest changed as a result of the July 2020 transaction between us. Did I read that correctly? Your statement, you did. I think that clearly represents my intention that the loan we were taking together was meant to be a loan secured by the property while Ms. Sammartinian kept the property. Do you disagree with that statement?
That's part of what I said at the time.
You were under oath at that time, weren't you?
Yeah, that's the truth. There's more that I said after that.
So you said, let's go into it. You know, after this, Ms. Sammartinian made claims on both the proceeds of the loan, whatever you want to call it, and the property. And that's not referenced in here. What did you mean by claims on both the proceeds of the loan and the property?
That she was trying to keep the house and the money that she got from selling the house.
Okay. And then you said, this was made as a gesture of good faith to Ms. Sammartinian to state that the house is going to remain yours because that is the spirit of the agreement that we entered into in 2020. Do you still stand by that statement?
Yeah, in 2020, when we made the deal, she said, I want to live here. I want to keep living here. And so I said, yeah, that when everything's over, the house can be yours. But I never said that she could get to keep the house and the money while I have the mortgage in my name. So I stand by the spirit of the agreement, and that's what I was trying to stand by with this document, and that's what I was trying to communicate to her when we were arguing in 2022. Like, after we split everything, if the house is what you want, like, we can come up with a way for you to have the house. You know, maybe you take a mortgage out, maybe you do one of the several ways that we learned about to refinance the house, but we can figure out a way for you to keep the house. But I never, not from the beginning, not when we were arguing, not even now, think it makes any sense for her to have the house and the money from selling it.
All right. Well, let me ask you what you meant by this in your deposition. I mean, you have to keep in mind that my house verbatim was on the title. So we were aware of that. Verbatim just meaning that that's what you said, right? This was an effort to reassure her that I wasn't going to try to screw her over. What did you mean by screw her over?
But this is kind of the same thing I was trying to talk about earlier. Like, the house was in my name only. Back then, you know, you could go online to like opendoor.com and get the house sold in like 7 days or something. And it had gone up a lot in value. And I was trying to tell her in words and, you know, with this document in writing, look, I'm not going to sell the house from under you. Like, we live here with 6 dogs. Your niece has 2 dogs. I'm not even trying to claim the money from the house having gone up in value. I'm not trying to screw you over. So that's what I meant in my deposition, and that's what I was trying to communicate with this document, like back in 2020.
So if I'm putting these pieces together, you're saying that she was still entitled to something in the house, and you wanted to reassure her that you weren't going to jeopardize whatever that interest was?
I was trying to reassure her that I wasn't gonna, essentially try to screw her over. So whatever it was that she thought she owned, whether it was the cash from selling it or the house, like I wasn't gonna try to double dip and take both from her.
Okay, so let's again just look at this. Does it ever mention the cash?
No, it doesn't. It doesn't talk about the whole thing.
No, it's talking about the property, correct?
Yeah. She wanted to make sure that I was going to hold up my part of the deal.
So then why do you keep bringing up the cash?
Because it's the other part of the deal.
All right, next. During that deposition, you said, page 78. So my primary reason for signing this
Objection,
document.
Your Honor. We're not seeing a question being asked in the deposition, so he's just reading that in the answer.
Sorry, I'll read the question. So, and I really want, this is the attorney. So, and I really want to be clear here. I did not ask what could it mean. And so to be even more direct, what was your understanding at the time you signed this document in November 22 about what the phrase ownership interest means? Same question I'm asking. At the time you stated, so my primary understanding, my primary reason for signing this document was to reassure Ms. Sammartinian and to have our conversations continue. Looking back at it, you know, with the distance for 4 years, looking at a very tumultuous time, my best understanding of the intent was this was in accord with our original verbal agreements in 2020 that Ms. Sammartinian would have the economic equity in the property throughout our investment proceedings, and that, I believe, is what it meant. Is that still your testimony today?
Yeah, and I think it's the same thing I've been trying to say, like all morning and all afternoon. If she wanted the value from the house going up in price, that was hers to claim, and she could get it by buying the house back from me at cost. The reason everything fell apart and we started arguing was my position is and was, okay, if you're claiming the house, then the money from the sale, that's shared because we're splitting the mortgage payment for that. And her position today is, no, that's not shared. That's my money. The house is mine too. But as far as the part about the house going up in value, I mean, that's what I said in my deposition. That's what I'm saying today. Like I understood our agreement at the time to be that was hers if that was the choice that she wanted to make.
So was it your understanding that this transaction, that the house was going to be hers?
Yeah, like when we ended everything and she wanted to keep the house and stay living there, that was the idea, that she was going to be the one that lived there. We'd split the money fairly, and then I'd move out.
So one of the things that you said in the deposition was that you wanted this to continue the conversation. This looks pretty final. Did you intend something other than what's written here when you signed it?
One of the things that I thought would happen after signing this was I thought she would give me my part of the investment account back. She didn't do that, so this wasn't final. Like, we had to keep talking.
Did you ask?
I did. I said, can we, I gave her the 167,000 number. And I said, can you send that back to me? And, once you do that, I've signed this paper. We'll then, I'll sell the house back to you for $231.
All right. So is it your contention that when you signed this document, you were not bound by the terms of it?
No, my position, I think better stated, more fairly stated, is I thought after signing this, she'd give me money back. And so this, I thought, was one step in an exchange.
Okay. So we were talking about habits earlier.
Yeah, we were smoking.
And my question to you was, did you have the habit of signing your name to things that you didn't intend to bind you?
No, so I still don't think, this all rises to the level of a habit. I think this document is more honest than the other ones. The other ones were designed to deceive other people, whether it's the FBI or the IRS. This one was designed to reassure. I mean, she wrote it, right?
Right.
The purpose was to reassure her. And I'd call this one incomplete instead of
Sorry.
misleading.
Got fat fingers today. Sorry about that. So this is the document we're talking about.
Yeah.
Okay. I want to look at some other documents that you guys brought. This one right here. Okay. This is what you guys were calling the engagement letter. Who drew up this letter?
We did this one together.
You did this one together. Were you guys actually engaged?
We were not.
Did you sign this document?
Signed it.
Did you intend for this to indicate that you were engaged when you actually were not?
Yeah, this was a dumb thing. We were trying to deceive and say something that wasn't actually true.
How about number 18? Did you draw this up?
No, I think this is a standard form that the bank sent us.
Okay. And is that your signature there?
Yeah, that's Ioana's handwriting, her signature, and then at the very bottom, it's my signature.
Okay. Were you guys actually engaged? Were you fiancés?
We were not.
All right. So I want to talk about this idea of habits. So we have a residence agreement that you said was fake. A roommate agreement that you signed several times that you said is not binding because you never intended for it to be binding. We have this gift letter. We have the engagement letter, 2022 affirmation document, and 3 lease agreements, Bosslandia lease agreements, that you say, at least to some degree, you didn't intend the language that was in them. Do you have a habit of signing documents that you don't intend to be bound by?
I don't think all of those are in the same category. So the residence agreement and the roommate agreement, those were designed to deceive. We were trying to help me with the FBI situation. We were trying to help her with the taxes. The rest of them, I think, the ownership agreement, like I think that one is better categorized as incomplete. And then the rest, I would say they're more like the lease agreements. I say that's more like scrolling through like the EULA, like the end user license agreements, like whenever you have to download an app. I never read all those things. Like I don't know what I'm attesting to, what kind of privacy information I'm selling away. So the rest of these documents, especially the lease agreements, I think fall in that category.
This one? This is one-liner? Does it fall in that category?
No, this is the FBI one. This one was designed to deceive.
Okay. Just take my point. There's a stack of documents that bear your signature that you claim aren't binding on you.
Yeah, I was dumb. We were dumb. We both did some dumb things here.
All right, I want to look at 5. This document also bears your signature. Is this document binding on you?
Not sure what document this is.
Sorry, this is the deed of trust that we looked at moments ago. Defendant's 5.
For the first mortgage?
The second.
Second mortgage, okay. Then the question was, is this binding to me?
Yeah, is this binding on you?
Yeah, I have to make those payments on the second mortgage. If I don't, they're going to take the house.
Is that because it's got the new signature?
I don't think the signature makes that binding. I think it's the reality of what's happened, right? The bank actually gave me money. I've actually been paying them back. So it's, the way we're acting. I think that's what makes this binding.
So only some agreements need to be followed. Is that what you're saying?
Not at all. Not at all. You asked me about what makes an agreement binding, and I said I think it becomes binding based on how you act.
Okay, well, let's refresh the jury's recollection about how you act. You testified earlier today that you sent a default notice in 2025 to enforce the roommate agreement.
I did.
So isn't that action in conformity with your intent to be bound by that agreement?
So this was 2 years into litigation. 2 years where Ioana had been arguing that it's a real document. It's like a real loan. And her position was that, she wants to keep paying me until I'm 80 years old. So I don't know what the court is going to decide. Like I said before, I think that's a question for the court and everyone here to decide whether that's a fake agreement, whether it's a real agreement.
I mean, you signed it, didn't you?
I did sign it. I also never intended it to be real. And when me and Iwana talked, we never.
Yeah, and that's the problem I'm trying to get at is how does Ioana know what agreements you intend to be bound by and which ones are just for fun?
I don't think it was confusing at all. Whenever we talked about it, we talked about that first deal where we'd split profits and I'd get my money back. Almost literally everything after that, from the fiance document to the FBI document to the roommate agreement with the misspelled roommate and the third wish principle. Everything after that was for other purposes, was fake. So I don't think it was confusing at all.
So, does the purpose of you wanting to enter into agreement get captured in the document itself? When we look at, for example, when we look at this residence agreement, does it say, in return for payment of $94,000, Zubair gets to hide from the FBI? Does it say anything like that? Does it say anything about the FBI?
No, it doesn't.
And then when we look at the residence agreement, sorry, that's the same thing. Roommate agreement. Does it say anything about taxes in this agreement?
Maybe if you look at that part about it's not a rental payment, instead it's a loan.
Does it say taxes?
No, it doesn't spell out taxes specifically.
So you're trying to get our eyes off these documents and into your story, isn't that correct?
I'm explaining what happened in the last 6 years so that the jury and the judge and the court can make their decision on what the right thing to do is.
Okay. All right, let's go back to 2022. So looking at Exhibit 3, if no ownership interest has changed as a result of the July 2020 transaction between you, then the property belongs to Ioana, and the 2020 deal was supposed to be like a home equity loan for Ioana, but in your name. Isn't that true?
No. So, if we had gotten the home equity loan where we pretended to be fiancés, the way we talked about doing that and the way we would have done it is, both our names would be on the house. We'd both have our names on the new mortgage. That money would be deposited into the trading account, which was shared. We'd get a separate bill, and then we'd split that separate bill up.
So she paid half of the mortgage through the rental agreements, though, didn't she?
If you count Elisa's rent as her portion, which I don't think that is something I ever agreed to.
Okay. Well, let's say that we do. Then why wouldn't it make sense for Ioana to keep the money from the home equity loan on her property?
This hypothetical where, Elisa's payments are from Ioana and they're not being filed on my taxes. In this hypothetical, I've essentially paid off her house for her and taken on this loan for something that I still don't understand. Like, why am I paying half the mortgage if she's getting to keep the house and she's getting to keep all the money, like with the whole $175,000? Like, that doesn't make sense to me. I just, out of the goodness of my heart, make it so he doesn't have a mortgage and all of a sudden I'm paying the bank instead of her.
I mean, you're asking that question, but this is at least the second time you did something like that, isn't it? You did the same thing with the $94,000. You gave her a 50-year term.
So that was to avoid taxes. But if you're talking about the original $94,000 that I gave her, In that deal, the agreement was that I was going to get paid back. In this description of the house deal that she insists on, I don't think I get anything for paying half the mortgage.
Okay, there wasn't an agreement to split profits off the 175 that was invested?
So that was one of her arguments. She was saying that I'm paying half the mortgage for 30 years, and if we have investment profits, I get half of the investment profits.
So you agree
But-
that was part of the arrangement?
Yeah, just like before, when we split the profits half and half, we're talking about splitting the profits half and half here too. But if the deal had ended like one day after I bought the house from her, I'm underwater like 100,000 from like half of the $200,000 mortgage. So I just spent $100,000 with this loan in my name, and I've gotten nothing. So I start underwater in her version of the deal by like 100,000.
Okay, but you wanted to spend time with her, didn't you? Wasn't that part of the deal too?
No, I don't think there was any kind of. I'm delusional in some ways, but I'm not. I'd like to think I'm not a crazy person. Like I don't ever think I wrote down as a condition of me buying your house, you have to spend 5 hours a day with me. Like,
Well,
nothing
you
like
know,
that.
there's not a time limit on it, but you guys spent some time almost every day together, didn't you?
Yeah, we did. I never demanded it. We had dinner together. We watched Star Trek together, but like that wasn't part of the deal. That wasn't part of like our financial life.
How can you say that when it's in writing at least 3 times?
What's in writing?
That there you've got this kind of sweetheart deal where she's getting low interest rates, she's getting a 50-year term, she's getting so much from you. And now after the deal, after your relationship is soured, now you're concerned about whether the terms are favorable.
So that's one of the things she tried to tell her family, actually, that, you know, I turned on her and I'm suing her because she rejected me. And that never made sense to me because, you know, in the time that we lived together, like, she dated other people. Like she had a few like long-term relationships. She had men in between. I never tried to punish her or say, oh, okay, you're dating someone, so like your interest rate's going from 2 to 5% or 15%.
Well, that's
Like
also not what I'm suggesting. But what I'm suggesting is that at the time that you entered into these agreements, your relationship was probably as good as it had ever been, correct?
No, I mean, I think probably like that first year that we hung out was probably like the healthiest.
So maybe in memory of that first year, you offered her these sweetheart terms. And forgive me for using the term sweetheart. I don't mean that as a pejorative. It's just that's my understanding of what they're called. When you have highly favorable terms with somebody. Isn't that the reason why you gave her highly favorable terms? Because you were close friends.
I mean, the reason we made the documents was to trick the FBI and to pay less on taxes. I think like I don't think, you know, I was trying to make it a sweetheart deal to you, like the way you're phrasing it. I don't think I was trying to make it a sweetheart deal to her. With the residence agreement and the rent, like I think we just took 94,000 and divided it by 380 to get to the 25 years or something like that. And then for the taxes, we tried to split it up over as many years as possible, so that way, you know, you have as long as possible to pay the taxes.
Okay. At a certain point, November 22, you wanted to do a margin loan in Ioana's account. Isn't that correct?
Yeah, that's correct. November of 2022, like we'd spent all the cash in the account. It was like $350,000, like buying Facebook, buying Apple. And I spent another $7,000 to buy more Facebook and Google shares, I think. And that was a loan against the account. So, you know, the account $7,000 was being borrowed against an account of like 350,000.
Did you tell Joanna about that?
You knew about it? I never
Tell her before you took out the loan?
I did. I told her that summer that, look, the market's continuing to go down. We're going to borrow money to buy more stocks. We'd done it before. We'd borrowed against the account before. So I told her that it was going to happen. She knew about it. It was something that we did regularly and we'd done before.
On December 27th, 2022, she didn't send you a text that said, did you really take a loan out in my name without asking my permission?
Yeah, this was when I was in North Carolina visiting my sisters. This was like the second time that I'd seen them after quarantine. I was there for Christmas, and she sent me this text, and then I think the follow-up texts said, tell me why I shouldn't, I'm paraphrasing, but it said something like, tell me why I shouldn't ruin your career and report you to the SEC right now.
Can I approach the witness, Your Honor?
Yes.
Does that refresh your recollection of the conversation?
Yeah, these are signal screenshots, and I did a pretty good job of paraphrasing.
And you do that without even turning the page. How about that?
Well, you know, my most important relationship in my life was falling apart. Do you happen to remember how it happened?
So let me ask you again. Did you take out a margin loan in 2022 without Joanna's knowledge?
I don't think that's accurate. I told her that this was going to happen. So the margin loan happened. The reason she's been so angry about it is she thought it happened while we were arguing. The margin loan happened in early September, maybe late August. I told her in the summer, like I'm reading my text here. I say, hey, good morning. I did mention over the summer that the plan was to use margin as the market dropped further. I bought, you know, there's a screenshot here of the statement, $7,000, $7,300 of margin loans against an account that's $344,000. Those stocks went up in value. Like in December when she was texting me, they were worth $9,000. So I don't think your statement that I did something in secret behind her back is accurate at all. I told her that this was going to happen. We'd done it before. When she got angry about it and tried to, you know, spring it on me as a gotcha, I said right away, yeah, this happened. I told you it was going to happen. We've made money on this. And then, you know, the rest of these pages are me saying, okay, well, if you don't want a loan, here are the ways we can deal with it. You can sell the stocks that we've made money on. You can deposit money. I can deposit money. Tell me what you want to do.
Yeah, approach, Your Honor.
Yes.
Did you express remorse to her about taking this loan?
At the time, I was apologizing a lot. I think, I mean, you have it in front of you. You feel free to read it off. But at the time, I was saying, look, I'm sorry. We combined our money. If, you know, it's leading to this, to us arguing like this. I'm sorry if, you know, you feel used, that you cooked like during the time that we lived together. Like I didn't mean for you to think that was something I was requiring of you or demanding. I was apologizing about a lot of stuff. I mean, like it got into like a really terrible place, and
Well, was she
wish
concerned? Well, according to the signal messages, didn't she express concern to you that there always be 2 months buffer, 2 months mortgage payments buffer in the account?
she said that after the fact. Like she said that when, she got angry about this loan. She said it in her angry email that she sent like after the talk with her sister didn't work. That wasn't something that we talked about like
Okay.
before.
So you did take the loan without her approval, isn't that true?
I don't think that's accurate. I told her this is how we're trading. She didn't say anything at the time that, absolutely not. I don't want to borrow money. We had made all this money with borrowed money. So I don't think it's accurate to say that I did it without her approval. She knew what the plan was. We'd done it before. I was open with her the whole time. She got angry about it after the fact because we were arguing and we couldn't figure out the situation with the house.
Did you try to redefine the terms of the 2020 deal because you were unsatisfied with the profits from the investment?
No, that's not accurate at all. Like I think I said this yesterday. Everything had gone up in value. The house went up in value. The investment account went up in value. So there wasn't unhappiness on my part about lack of profit.
Did you, in February 2023, did you schedule repairs at the house over Joanna's objection?
I did do that. So the garage door had broken, and instead of locking it, like anyone could walk up and just lift the garage door and go into the house, where Elise and her partner lived, where the dogs were. So I called a repairman, like spent the $250, and I got the garage door replaced.
Did you then text Joanna about the same time, claiming that the ownership of the property was yours?
Yeah, I did. So I was up in Prescott in an Airbnb, like I'd moved out of the place, and she was still texting me like, why did you show me the fake document? Why are you showing fake documents to people? And then she got angry about me repairing the garage door, which was a security issue.
And you stated to her, "This is my property. I've been letting you stay there currently as a courtesy." Isn't that correct?
I did say that, yeah. And I mean, that was just the truth. I told her, my name's on the deed. Like, if you're not going to talk to me, because she hadn't been talking to me except to say, why are you showing fake documents to people? For like 6 weeks at that point, she was demanding that I move out, and I had. So yeah, I told her what the facts of the situation were that the house is in my name, and yeah, you can stay there until we figure this out. That's what I told her.
Isn't that a direct contradiction to the graph paper agreement?
Yeah. So the deal was, the agreements weren't holding up at this point. Like she was making no move at all to give me my money back. This was the start of the breakdown, I guess. Now, I don't think it's fair to say that it's like a complete contradiction, because what I was telling her was a reminder of the situation as it stood at the time. And as it stands today, it is just my name on the deed. Like, I wasn't taking back the offer for her to buy the house back from me for $231. I was just reminding her that the way it stands right now on paper, the house is mine. And I was telling her, but I'm going to let you stay there until we figure this out.
So if she bought the house back from you at $231, but she'd only paid $45,000, that results in a windfall to you, doesn't it?
No, not at all, because I have to pay the mortgage back.
Yeah, but she'd only paid $45,000 at the time. She's assuming the mortgage.
No, she wouldn't be assuming the mortgage. So the mortgage was not assumable. So, at the time, like 2 years, let's say the mortgage is down to $200,000. I don't know what what the math actually works out to. She pays me 231, 200 goes to the bank for the mortgage and I'm left with the 31 or whatever. So even like if you just look at cash in and out of my bank, it's not like I'm profiting like from this.
Did you pay back? You pay back all, or sorry, strike that. Okay. So you're telling Ioana she's a guest on the property, and then you stated that once she made it clear she did not, or sorry, that you did not intend to honor the investment deal, that there was no more reasonable expectation to believe that she had ownership interests. Isn't that correct?
Yeah, I think I said that today. But to get back to something you said earlier, I never told her she's a guest on the property. I said, I'm letting you stay there as a courtesy. I think that's an important difference.
How so?
I think it's nicer in tone.
Okay, but what about substance?
I think it is also different in substance. Like saying you're a guest implies that you have like a limited time there. Whereas,
Okay.
saying, yeah, I'm letting you stay there, that seems more indefinite.
Letting you stay there as a courtesy. So what happens when the courtesy is over? Does she become a squatter at that point?
We never found out. I moved out, she moved out, she moved back in. So we never found out.
Okay. So in your deposition, you testified that the agreement, you believe the agreement to be null and void because Ms. Amartinian had disposed of all the investments, which you found out in March 2023. Is that correct?
Yeah, I said that.
So that implies that a valid contract existed until March 2023.
Yeah, we had a deal. Like I thought it was, that deal at the beginning where we split profits 50-50. And, in March, like I moved out in February. I sent her that text, like right as I moved out, reminding her that the house is still in my name. And then that first week of March, she sold all the stocks in the account and bought herself a house. So to me, it was clear that there was no deal left. Like if she's going into the account, selling everything, and then buying herself a house. And she did that because like when we were talking about unwinding everything and she got heated, she told me about bankruptcy laws that she was looking up. And she told me that, like if I go buy a house with this, like it's my primary residence, you can't come after me for it. Like they can't take it from me in bankruptcy. So to see her like follow through on her threat like that, made it very clear to me at least that there's no deal anymore. She's getting ready to sue me. I'm suing her. So yeah, none of the agreements that we had before.
When did you file the lawsuit?
April 17th of that year, 2023.
2023. Did you threaten to evict her?
Never.
Did you threaten to evict anybody else?
So there was, I forget when it happened. Might have been 2024. It might have been 2025. But the niece and her partner who lived there, they sent their rent to Ioana, who then sent it to me 1 month. And I talked to my lawyer, and I said, look, I don't know why she's doing this. I think maybe she thinks it like gives her a better claim to the house. What do I do? And I was told, and I agreed with this, to send Ioana the money back and then tell the niece and her partner, hey, you guys can't be using Ioana as a middleman here. Like, I don't know what she's up to, but you guys have to pay me or else you're going to get evicted. So I did do that.
So you're trying to assert your role as owner, landlord, correct?
I mean, I was, yeah, essentially throughout the whole proceeding of this lawsuit, one of the things up for debate has been who owns the house that we're fighting
At
about.
what point was your name, or was Joanna's name taken off of the lease agreement as landlady?
So I sent them a lease in 2023 to sign, and they never did. So after that point, I think they were paying months a month. So there's never been a lease that is updated to include just me.
Okay. When you took the home equity loan out on the property, did you inform the bank that you had signed a document in 2022, this document, stating that you had no ownership interest in the property?
No, I did not. I didn't think this was valid at that point.
Why was it not valid in 2022?
Well, because you went into the investment account and claimed the whole thing for herself.
Okay, let's clean up that timeline then, because you said that there was a valid contract until March 2023, isn't that correct?
I think I implied that by what I said earlier. So like up until the point where she cleaned out the investment account, like I still had hope that we would somehow figure this out.
So then how does that affect this document? If that cleaning out of the account took place in the next year, wasn't this still valid according to your timeline?
I think maybe I wasn't clear. Maybe you mixed up some dates, but the way it happened was 2022 October is when we decide to start unwinding things. We argue. We meet with her sister January of 2023. I move out in February of 2023. March of 2023 is when she cleans out the investment account. June of 2023 is when I take a second mortgage out against the house.
Okay. So did you apply for any loans in 2022 in order to get the home equity out?
No, that would have been shady. I didn't do that.
All right. So I'm going to get back into your deposition. All right. The attorney questions, when you took the home equity loan, the second, for lack of a better phrase, when you took the home equity loan out on the property, did you inform the bank that you had signed a document in 2022 stating you have no ownership interest in the property? No, this document was null and void because I believed it to be null and void because Ms. Sammartinian had at that point disposed of all the investments and went and purchased a property for herself in cash, which I knew in March. Is that still your testimony today?
Yeah, I think that's what I just said.
Okay. All right, let's go back to the tiny homes. So you mentioned in the episode of the tiny homes, we'll call it, that Joanna had this idea about taking money and purchasing tiny homes. Isn't that correct?
I did say that, and that's accurate. The idea started with her.
Did you ever tell her no?
No, I didn't tell her no to anything for, the time that we spent together. Not until the very end when we started arguing about money. I said yes to almost everything, every idea that she had.
Okay. Did you think it was a good idea?
I thought it was a crazy idea. I thought it would be an adventure. I wasn't sure how it would work, but I was on board.
Okay. You also testified yesterday that Joanna, that you had objected, or sorry, you had withdrawn. You had withdrawn 10,000 and she never objected to that. Isn't that correct?
Yeah, that's right. She knew about it. Our finances were shared.
At what point did she find out?
Right when it happened. I'm pretty sure, like, because, you know, it was being used to pay the mortgage and the groceries. And I said, hey, you need to put $10,000 in the shared bank accounts. I'm pretty sure it was something, I think 2021 is when I took the money out. So like that year is when she knew about it.
Okay. All right. And with respect to the showering outdoors, how long did you do that?
That was probably like three or 4 months, because we built an outhouse with a shower pretty soon before winter came.
Okay, so it's not like you were showering outdoors for years.
No, not for years, just in an outhouse for years.
Okay. Does the house that you live in now, does it have indoor plumbing?
Yeah, I couldn't, I didn't look, but I don't think I could rent a place nowadays without indoor plumbing.
What do you mean you didn't look?
I don't think there's a spot like on apartments.com or Zillow.com where you can type in no plumbing.
Oh, okay, yeah, I gotcha. All right.
You let me know when there's a good time to break.
Just want to. Did you design the tiny home?
No, she designed them.
Were you able to update it?
Was I able to update the design?
Yeah. Like, were they like customizable?
Yeah, they were customizable. So I mean, they were through Home Depot. Like if you've ever been to a Home Depot, you probably see the sheds like in the parking lot.
I don't shop at Home Depot. Sorry.
Right, different walk of life, I guess. But for anyone who's been to Home Depot, these are the sheds that they have in the Home Depot parking lot. And you know, you go onto their site and they have like a little kind of like architect tool. She was spending like hours a day on this thing, getting the size right, getting like, so there were 2 stories. Each story was really small, but like, you know, like placing where the stairs would be, where the windows would be. She would show me her designs and I'd comment on them. I was like, oh yeah, the window should definitely face the sunset. But she was the one designing them.
And could you have added a kitchen?
No. So one of the things that they wouldn't do when they build it for you is they would not do plumbing for you. They do electrical, but like the city ordinances, she knew it better than me. So the way she explained it to me was that, yeah, we can put electrical into the sheds without having to go to the city and get permits, but we can't do plumbing to the sheds.
So how did she get a kitchen?
Built it for her. So
You built it.
yeah, I took vacation from work. You know, we got a lot of 2x4s from Home Depot again. Grabbed a stove off of OfferUp, like that was the thing instead of Craigslist in the day. And yeah, I guess we built it together. That's fair. Like she helped a lot, and like it was like a project that we were actually proud of. But yeah, we built additions onto hers.
Okay. Well, I guess now's a good time, Your Honor.
Folks will recess for about 15 minutes. Please remember the admonition. Go ahead and step down. We're going to talk for a minute. Be seated if you want. If you need to stand and stretch, you're welcome to do that. The record will show that the jury's left. I want to talk to y'all about time. The jury's starting to clock watch, and y'all are running out of trial time. With one important witness to go. I mean, maybe you plan to do an hour apiece with Ms. Martinian. I doubt it. So here's where we are. Plaintiffs used 235 with 125 left for your redirect. And if you're going to call her in your case in chief, your direct and your redirect and your closing.
Yeah.
And you've used 150 52, Mr. Richardson, with 208 left. Doing better, but the jury's getting that look. And so y'all might want to think about tightening it up a little bit.
Very good.
We've spent 6 hours on this witness total so far, so that may be time to move on to some specific points and get to the next witness. I'm not telling you how to do it. I'm just telling you what the time is, and we will finish this trial on Thursday.
Very good.
Let's talk about the jury instructions. Not talk about the jury instructions. Let's talk about scheduling. I'm thinking 8:45 tomorrow morning. That gives us a half hour. I've got a 9:15 I've got to take. But that gives us a half hour to settle preliminarily jury instructions and verdict forms. We'll do a final run through before we do closings, because some things will happen in the trial after that, but at least to get the forms in order. Does that work for you all?
Yes, Your Honor.
So you're talking, I'm sorry, Your Honor, 8:30 you said, or what time?
8:45.
8:45, that does work.
All right.
Thank you.
Then we'll get you all the verdict forms that you don't have already, unless you've got them all. Do they have all the verdict forms or just the interrogatories? Yeah. So we'll get you the verdict forms this afternoon. We'll finalize and semi-finalize the draft of the preliminary jury or the final jury instructions and get those to you this afternoon. And then we'll be good to talk tomorrow at 8:45. Yes.
One question, Your Honor. I've handed the clerk a copy of our deposition because when I call Ms. Sammartinian, which I intend to do, I'm probably not going to do any rebuttal, just to be clear. When I called Ms. Sammartinian, the clerk's been handed a copy of the deposition transcript. There's the two questions I have are, just a technical one. I'm going to move to admit selections into evidence. I have a real copy. It's
Of the
there.
deposition?
Yes,
I will
correct.
deny that motion. You may read deposition transcripts
Okay.
as cross-examination while you've got the witness. If you wanted to just read her deposition as substantive evidence, you'd have to submit deposition designations and give him a chance to object. And it doesn't sound like we have time for that.
No. Fair enough.
The jury doesn't get the deposition transcripts.
Okay, understood. And may I actually publish, I don't want to hand him read out the deposition transcript out loud. May I have her read it? Read the selection, ask her a question, and if it is, and then ask them to see it on the screen?
I generally allow that. Any reason why I shouldn't allow that for either side?
No, Your Honor.
Okay, so ask her the question, however she answers it, I can show her it.
However you want to do it.
Thank you, Your Honor.
We'll see you in 15.